Thanks very much, and welcome everyone. This is Andy Pincus. I'm a partner in our appellate practice in our DC office, and I'm joined today by Lauren Goldman, who's a partner in our appellate practice in New York. And we appreciate your joining us to talk about recent doings at the Supreme Court. A couple of housekeeping details as we go along. If you have questions, please use the Q&A panel on the lower right-hand side of your screen. If you type in a question, we can see it, and we'll try to answer them as we go along. If we can't, we'll, of course, get back to you after the presentation is over. Second, regarding the all-important question of CLE credit, we will be reading an alphanumeric code at some point during the presentation, and as many of you know, in order to get credit, you have to record that magic number on the virtual sign-in sheet that was emailed to you with the login instructions for today's program. And finally, the views that Lauren and I expressed today are our own and should not be attributed to our firm or our clients. With that, let's get started. Obviously, the first big event at the Supreme Court was the addition of a new justice. Justice Gorsuch was confirmed and joined the court in time for the April arguments, so he had an opportunity to participate in merits decisions in some 13 cases and to begin to vote on whether to grant cert on cases for next term. Many of you have probably read lots about Justice Gorsuch, but just to underline a couple of things, he started his career after his clerkships as a litigator in a high-powered law firm, so very experienced in the trenches of litigation. He went from there to the Justice Department and from the Justice Department to the 10th Circuit, and so he has an experience as a lower court judge. We know a few things about his views on some areas of the law. He's a committed textualist, very focused on using textual analysis to resolve both statutory and constitutional interpretation questions. He is also a skeptic about administrative agencies. The Chevron doctrine of deference to agencies' interpretations of statutes has been something that has been more contentious in recent years. He rejects it entirely as something that trenches on the constitutional authority of the courts and Congress. He's also someone, probably because of his litigation experience, who's worried about agency regulations and complex statutes and the extent to which they provide fair notice to regulated businesses and people about what's expected of them. In the oral arguments in April, no surprise, given his record on the 10th Circuit and the current court, very active questioner, very sharp questioner. He's written one majority opinion for the court so far, an issue under the Fair Debt Collection Practices Act of statutory interpretation, as you would expect given his history, very close textual analysis. Parts of the opinion, if you, like I did in grade school, had a teacher who taught grammar by making you diagram sentences, there was a lot of virtual diagramming of the sentences in that statute in this opinion. He has not been shy about expressing his own views. His first separate opinion was one that took the majority to task for deciding things that didn't have to be decided and not being willing to let the lower courts develop the law before addressing it. And in the more contentious decisions that came down earlier this week, he joined and wrote several dissenting opinions. So I think it's clear that he's going to be very vocal about expressing his views. Can turn to the next slide.
So turning from the narrower to the more general, each year we analyze the court's business docket, and we focus on the cases where we have a business on one side and either an individual or a government entity on the other. We leave out the business on business cases because what we're trying to do is see what the win-loss record is for business in the Supreme Court. And this year was not a blockbuster term. There were some cases that we think will have a lot of significance for businesses going forward, but there were also a lot of very narrow cases this term. And there were only 15 cases that met our criteria. And that was pretty interesting because it's a very low number compared with the last several terms. Usually this number hovers in the low to mid-20s. So 15 was a small docket, but the good news is that businesses won 13 of those 15 cases. 8 of them were unanimous, indicating that many of these outcomes were obviously not at all controversial. I think there was only one 5-4 decision in our analysis this year, and we'll talk about that shortly. And as I mentioned, many of the holdings are quite narrow or even neutral to business interests. You know, there's always cases where the business was on one side this time, but next time the business could be on the other side of the same issue. So we'll try to focus our discussion today on some of the more interesting and consequential decisions. And from this point, I think we jump into the actual cases.
We jump into the cases. And the first area is a little bit of a flashback to first-year civil procedure, personal jurisdiction. It's been a little bit of a sleeper, but in terms of tools for businesses to use to rein in unjustified litigation, the court's decisions in the personal jurisdiction space are really at the top of the list. So if you remember back to personal jurisdiction, it comes in 2 varieties: general jurisdiction, all-purpose jurisdiction, which means that the forum can hear all claims against the defendant, no matter where the claim arose, and specific or case-linked personal jurisdiction, which is limited to claims that arose within the forum and that have a connection with the forum. A couple of years ago in the Daimler case, the court addressed this question of all-purpose personal jurisdiction, general jurisdiction, and said general jurisdiction is available only in a corporation's state of incorporation and state of principal place of business. Before Daimler, many lower courts applied the rule that if a company was doing significant business in a state, that was enough to subject it to general jurisdiction. So Daimler was a quite significant cutback on the availability of general jurisdiction, and as a result, some state courts reacted by saying, well, if we can't use general jurisdiction anymore, maybe we can expand the scope of specific case-linked personal jurisdiction in order to keep in our court claims that were originally entertained on a broad general jurisdiction theory that's no longer available. So the court heard 2 cases this term involving aggressive assertions of jurisdiction and overturned the state court's decisions in both. The BNSF case, really principally about trying to expand Daimler's view of what constitutes general jurisdiction. That case involving a claim in Montana against BNSF that had nothing to do with Montana. The injury didn't occur there, the plaintiff didn't live there, the plaintiff wasn't stationed there as an employee, but Montana asserted jurisdiction on the theory that Daimler really was about foreign corporations, non-U.S. corporations, and there should be more generous general jurisdiction available for U.S. corporations. And the court said, no, we really did mean what we said in Daimler. General jurisdiction, absent extraordinary circumstances, is limited to the 2 places, state of incorporation, state of principal place of business. Bristol-Myers Squibb involved specific jurisdiction. This was a situation that I'm sure many of you are familiar with, the mass tort action. Product liability cases relating to BMS's drug Plavix were filed in California, 8 separate actions involving some 600 and some odd plaintiffs, each asserting individual claims. So this was not a class action, this was a mass action. 86 of the plaintiffs were California residents and alleged that they were injured in California and bought their drugs in California. And as to them, there was no dispute that California could assert specific jurisdiction. There were some 592 plaintiffs who were not from California. They were from 33 other states. They had nothing to do with California in terms of their injury, residence, place of purchase of drugs, or anything else. The California Supreme Court said, we can nonetheless assert specific jurisdiction over these claims of the non-California residents using a sliding scale test that basically says, well, BMS does a lot of business in California. Sure, it's not enough for general jurisdiction, but we can take that into account, take into account the fact that we have these claims by California residents that involve the similar course of conduct, product liability claims relating to the same drug, and that's enough to give us the ability to assert specific jurisdiction over the non-California plaintiff's claims. And the Supreme Court, by a vote of 8-1 with only Justice Sotomayor dissenting, said, no, you can't do that. There has to be a link between the plaintiff, the defendant, and the forum and the claim with respect to every single claim. And the fact that there are some claims that the forum can entertain means nothing about whether it can entertain other claims. Each claim has to be analyzed separately and have that link between the claim and the forum. So a very important restriction in the mass action context that's already had some consequences with respect to mass actions in other states such as Missouri. You can go to the next slide. The impact of BMS is not going to be limited to the mass action context. Switching to class actions for a minute, the question is going to be, okay, in a mass action, the forum has to have specific jurisdiction with respect to every plaintiff's claim. What about class members? Shouldn't that analysis mean that a class action can only be brought in a place where the forum can exercise personal jurisdiction with respect to each class member's claim, not just the named class members, but also the absent class members? As folks probably know, in a number of courts, the rule today is, as long as there's personal jurisdiction with respect to the named plaintiff's claims, no inquiry is needed with respect to personal jurisdiction over the absent class members' claims. We think that BMS is going to change that to a significant degree. The Supreme Court has been quite clear that the class action device can't be used to take away defenses that a defendant would otherwise have. BMS makes clear that outside the class action context, this personal jurisdiction defense would be available with respect to all individual claims, and therefore we think there will be a significant effort by defendants to use this decision to rein in forum shopping by class action plaintiffs and their lawyers. And we foresee a lot of litigation in that area. Obviously, one of the things that BMS doesn't say is how much of a connection between the plaintiff's claim and the forum is enough to permit specific jurisdiction. In BMS, it was relatively easy because the non-California plaintiffs had no connection whatsoever to California. There was some discussion in the briefing in the case that the court didn't have to reach. Should proximate causation be required? Should the actions of the defendant within the state have to be a proximate cause of the plaintiff's claim? Is but-for cause a lower standard enough? Is substantial connection enough? This is an issue that will be litigated intensively because plaintiff lawyers are going to respond to BMS and other decisions by saying you don't need much of a connection for specific jurisdiction, and obviously defendants are going to take the opposite view. There is a case called GlaxoSmithKline against Myers pending in the Supreme Court on a cert petition that raises this question, again in the drug context. We filed an amicus brief for the Chamber of Commerce suggesting a substantial connection test. One of our worries, frankly, is that using proximate cause, although a tighter standard, carries with it the risk of accelerating to the personal jurisdiction discovery phase, lots of merits discovery, and may require defendants to subject themselves to more discovery than they would want. So that's just some of the balancing that will go into how defendants begin to argue that issue. The other open issue on the personal jurisdiction front, a number of states and plaintiffs' lawyers are responding to the Supreme Court's Daimler decision by saying that their states should condition the right to do business in the state of a foreign corporation, a corporation registered in another state, on a consent to general jurisdiction. There's been some litigation over existing statutes that for the most part courts have held that the statutes don't require consent to general jurisdiction on the theory that to require that would raise grave constitutional questions about conditioning the right to do business on giving up a constitutional right, the due process right to be protected against unfair personal jurisdiction. But some states, including New York, are considering explicitly enacting statutes that explicitly require this condition, and obviously then we're going to see direct constitutional challenges to those statutes. So personal jurisdiction, a big area of potential future leverage for defendants.
Go to the next slide, please. So turning to securities cases, one of the most important and interesting ones this year was actually a criminal case. And I'm sure everybody's familiar with the Supreme Court's decision in the early 80s in the Dirks case, where the court held that to establish insider trading, the government has to show that the insider who shared information and tipped somebody off to buy or sell securities breached his fiduciary duty by receiving a personal benefit in exchange for that information. And until this decision from the Supreme Court, the circuits were split over the nature of that benefit. The Second Circuit had held that the benefit essentially had to be money or property, that it had to be of a pecuniary or similarly valuable nature. But in this case, in Salmon, the Ninth Circuit was faced with the question of what happens if the tipper and the tippee are bonded by a close family relationship. So here, the defendant's name was Salmon, and his brother-in-law, Mayer, was an investment banker. And Mayer shared inside information with his brother, Michael, in order to help Michael and fulfill his needs. Michael then traded on the information and passed it along to Salmon, who also profited from it. And the question was whether by passing along this information to his brother, Mayer had violated his fiduciary duty. And the Supreme Court held that the jury could find that, in fact, he did, because the court said if Mayer had traded on the information himself and then given money to Michael, he would have received a psychic benefit. So this is exactly the same thing. He passed along the information, Michael made money, that's a gift, and it was a psychic benefit to Mayer, and so therefore he did breach his fiduciary duty. Can we go to the next slide, please? Kokesh is an interesting case, less for the holding and more for other things that the court said along the way. So this is a case about the SEC's ability to seek disgorgement as a remedy in enforcement actions. And Mr. Kokesh had stolen $35 million from investors between 1995 and 2006. And the SEC brought an enforcement action in 2009. And it agreed that the statute of limitations blocked it from seeking monetary penalties for the period prior to 2004. But it thought that it could seek disgorgement as a sort of equitable remedy going back to the dawn of time, or in this case, starting in 1995. And this is emblematic of a number of efforts that we've seen by federal agencies and other parts of the government to work around limitations on monetary penalties by seeking disgorgement. And here the question was the applicability of the statute of limitations. And the statute says that it applies to any action for the enforcement of any civil fine, penalty, or forfeiture. So the question is whether disgorgement is a penalty subject to the statute of limitations. And the court held that it is, because the purpose of disgorgement is to remedy a violation that is committed not against an individual but against the public, which means that its purpose is really to deter. Deterrence is inherently punitive, and the defendant is identified as somebody who has done something wrong. And finally, the court said disgorgement doesn't just restore the status quo, because often the defendant has to give up more than it kept in profit. And so the court said that the statute of limitations did apply, did limit the period for which the SEC could seek a remedy. And it dropped an interesting footnote which questioned whether, in fact, the SEC should be able to seek disgorgement in enforcement actions in the first place. So by doing that, the court is sort of inviting other parties to take that issue up to the court in a future case. Slide, please. So CalPERS is a decision that came out either yesterday or the day before. I think I've lost track of what day of the week it is. And the question here was whether the filing of class action complaints tolls the statute of repose as to absent class members. And this is a really, really interesting decision and has a lot of implications for future cases. So back in 1974, the Supreme Court held in the American Pipe case that the filing of a class action does toll the statute of limitations. But statutes of repose and statutes of limitations are very different. They serve different purposes. Statutes of limitations tend to be short. Here, the applicable statute of limitations was only a year. And they run from the time when the claim accrues, when the plaintiff could file suit. A statute of repose works differently. It's generally a longer period, and it runs from the date of the defendant's conduct. And the purpose of a statute of repose is to say to the defendant, look, after this period of time, nobody additional can sue you. You know what your liability is for this conduct. And this was a 5-4 decision, and the court said the majority held that statute statutes of repose are not told by the filing of a class action, because allowing somebody to opt out, as CalPERS did here, of a class action and file a new lawsuit more than 3 years after the conduct took place would vitiate that sense of finality that repose is designed to offer. And the court further said that American pipe tolling is equitable in nature, and so it's trumped by the language of the statute. 4 justices dissented. I think the dissent was written by Justice Ginsburg, joined by all the other liberal justices on the court. And they said, look, the initial filing of that class action put the defendant on notice that there were lots of people suing it for this conduct. So as far as the statute of repose is concerned, the defendant is aware that it is liable to all of these people. By opting out, the dissenters said, CalPERS just sought to take control of the piece of the action that had always belonged to it. You know, what the dissent pointed out, both at argument and in their opinion, was that there are a lot of practical applications of this and sort of some practical problems that it creates. In a class action where the potential damages are large, absent class members have a strong incentive to protect their right to opt out later by filing their own pieces of paper before the statute of repose expires. So that piece of paper could be a motion to intervene, it could be a protective complaint, but either way, the courts are going to likely see more filings by absent class members. What's interesting about this case is that we think it's going to apply not just to a situation where somebody wants to opt out of a class action after the repose period expires, but also we think it applies in the situation where a class is either the court rejects class certification or ultimately decertifies the class after the repose period has expired. We think absent class members will then be out of luck and will be unable to file their own actions. Can we go to the next slide, please? Up next, the court has granted review in 2 securities cases for next term. Digital Realty Trust concerns the question of whether Dodd-Frank's anti-retaliation rule applies to people who have not reported the alleged misconduct to the SEC, but instead have filed internal reports. And the Cyan case, SLUSA permits certain fraud actions with more than 50 claimants to be removed to federal court. So this case will address the question of whether that provision also strips the state courts of jurisdiction to hear these cases in the first instance. Next slide, please. Turning more directly to class actions, Microsoft versus Baker is very interesting because the 2 wings of the court took 2 different routes to get to the same result. All 8 justices who heard the case agreed that what the Ninth Circuit had done was wrong, but they disagreed very strongly about why. So everybody knows that class certification is the pivotal moment in a class action. If certification is denied, that may be what plaintiffs often say is the death knell for their claims because the claims are not large enough to be worth pursuing individually. If class certification is granted, then the defendant is suddenly seeking a lot more potential liability and a lot of pressure potentially to settle the case. So both sides would like to have the opportunity to appeal directly from an adverse decision on class certification. But under Rule 23, review of an adverse class cert decision is always discretionary in the Court of Appeals. And the plaintiff in this case decided that they could get around that rule. What they did, the district court in this case, struck the class allegations from the complaint. And the plaintiff said, okay, I want to appeal this, but the Court of Appeals denied interlocutory review. So the plaintiff said, okay, I'm going to voluntarily dismiss my claim, get a final judgment, and take that up on appeal. And the plaintiff said, but I reserve my right to revive my claims if I win the appeal and I get the class allegations reinstated. And the Ninth Circuit held that this was okay, that the plaintiff had gotten a final judgment by voluntarily dismissing their claims, and that there was jurisdiction in the Court of Appeals to hear the challenge to the denial of class certification. Now, this is clearly wrong because under the federal rules, it's improper for a plaintiff but not a defendant to have a unilateral right to appeal from an adverse class cert decision. And the majority in this case was written by Justice Ginsburg, and she said the reason that that's wrong is that there's no final judgment. She said by voluntarily dismissing the claim but reserving the right to revive them, the plaintiff didn't get a final judgment from the district court. And then she said quite correctly that this tactic invites protracted litigation and piecemeal appeals, and it undercuts the discretionary regime that is established by Congress and by Rule 23. Can we go to the next slide? The concurrence, which was drafted by Justice Thomas, joined by the Chief and Justice Alito, said that the majority had reached the right result for the wrong reasons. Clearly, the issue here was not just that there was no final judgment, but really that there was no adversity between the parties after the plaintiff voluntarily dismissed the claims, and therefore no case or controversy for the Court of Appeals to hear. The plaintiff at that point wanted the case to be dismissed. The defendant wanted the case to be dismissed. And so everybody agreed on what the judgment should be, and therefore there was no adversity between the parties. And the dissent explained that the plaintiff's interest in reversing the order and getting class certification was not enough without an underlying individual claim. That was not enough to support Article III jurisdiction. And this is very interesting because it is further evidence of a lot of interest on the Supreme Court in tactics undertaken by class plaintiffs that separate the idea of class cert from the underlying claims asserted by the plaintiffs in the class. What we've been seeing from a number of the justices on the court are statements that exhibit concern about the extent to which a class action can sort of mask the underlying problems in individual plaintiffs' claims. So last term, in the Tyson Foods case, the court had granted review of the question whether a class can be certified if it includes a number of uninjured plaintiffs who would not be able to file suit on their own. And the court ultimately didn't reach that question because it found that it hadn't been properly preserved below, but Chief Justice Roberts made a point of saying that Article III does not give federal courts the power to order relief to any uninjured plaintiff, class action or not. And so we think the question that's really coming down the pike is whether Article III requires that absent class members have standing and could therefore bring suit on their own, which is a nice segue into our next topic, which is a look back at the impact of last term's decision in the Spokio case, which Andy argued.
Yeah, we thought it would be interesting to flag for people what's happened in the last year regarding Spokio, because standing is such a all-inclusive issue and affects so many cases. Just as a refresher, recall that the court held in Spokio that Article III requires a concrete injury even when the plaintiff has alleged a statutory violation. The question there was a Ninth Circuit rule that said as long as you've alleged a violation of the statute, doesn't matter that no adverse consequences in the real world have either occurred or are threatened, the statutory violation is enough. And the court said, no, it's not enough. You have to have an injury that actually exists and that is real and not abstract. At the time Spokio was decided, which was after Justice Scalia passed away, the plaintiff's bar took the position that Spokio didn't really change the law very much. We had some blogging back and forth about whether that was true or false, and I think we can say what a difference a year makes in terms of what's been happening in the lower courts. The plaintiff's bar argument that this doesn't change anything and a statutory violation is enough has been squarely rejected by all of the courts of appeals that have considered it, and most reject that argument whether the statute is labeled procedural or substantive. There's some language in Spokio that's been seized upon to say, oh, this only applies to procedural statutes, and if it's a substantive right, you don't need real-world injury, and courts have said, no, that's not right. There has been particular attention in the area of statutorily required notices because, as anyone who's doing business in a regulated area knows, there are often a lot of required notices. And pre-Spokio, a lot of plaintiffs' lawyers claimed failure to provide the notice, as the statute required, was sufficient injury to give rise to statutory damages claims typically. And if you had a class of 1 million people and a statutory damages claim of $1,000, pretty soon you were into some real money. Many courts have addressed this issue. Outside the context of the Fair Debt Collection Practices Act, there have been some good results with lower courts saying, no, just failure to get notice by itself is not enough. The plaintiff has to show that as a result of that failure, something bad happened to him or her. In the FDCPA context, there's still some work to do because courts there have been holding, really because the 11th Circuit got out in front on the issue, that the failure to give the proper notice is enough. And the last question that's being addressed is, how does a court decide whether Congress intended to authorize suit for intangible injuries that otherwise wouldn't be actionable? And there, courts are beginning to recognize that the test isn't just, did Congress create a cause of action? The test has to be, did Congress say something in the statutory text to indicate that it was conferring a broader right to sue than otherwise would be available? These are issues we've been briefing, other defense firms have been briefing, and I think now that we have a fully constituted Supreme Court, my guess is that Spokio issues will begin to come back to the court in the coming year, and we're going to see some clarification and I hope solidifying of the progress that we made in Spokio. Turning to an area of lots of attention this year, the court decided about 60 different cases, 60-some cases on the merits. 6 of them were intellectual property cases. So again, it's an important area of the economy. It's an area the court cares a lot about, and it was a big area of focus this year. And the decision with the greatest impact by far is T.C. Heartland, which deals with venue in forum shopping in patent cases. If you practice in the patent area, you probably know about this, but if you don't, it's interesting to see some parallels here with the personal jurisdiction cases that we talked about earlier. There's a special statute for patent venue, which you see on the screen, suit where the defendant resides or has committed infringement and has a regular and established place of business, and an old Supreme Court decision had interpreted resides in that statute to mean state of incorporation only. But of course, there's also a general federal venue statute that authorizes suit where the defendant resides, but defines residence as any state where the defendant is subject to personal jurisdiction on the claim, much, much broader. The Federal Circuit, which controls patent law issues, had held that general test for residence was what applied to patent cases. And as a result of that, patent cases were concentrated in just a few districts around the country, including in the Eastern District of Texas, which had structured itself as a venue that was particularly friendly to patent claims, and some years had 25% or more of all the patent claims filed in the country. This issue came to the Supreme Court. Lots of briefs back and forth on forum shopping and the propriety of having claims concentrated here, but the Supreme Court ultimately focused on the statutory text and said, we hold unanimously that venue is limited to the districts that are permissible under the stricter patent venue statute. That's going to be a revolution in patent claims, a very, very big constraint on forum shopping by patent plaintiffs, and we're going to see patent cases distributed in different places around the country, but certainly in states like Delaware and in places like the Northern District of California, where there are lots of regular and established places of business or states of incorporation of companies that are patent defendants. We can go to the next slide. The other big patent case, full disclosure, it's a case that Mayor Brown handled and that I argued, deals with the patent exhaustion doctrine. How long can a patent owner assert patent rights? That doctrine holds basically, as you see on the screen, when there's an authorized first sale of the patented item, all of the patent rights are terminated. And so the patentee can't use the patent laws to control subsequent use or resale. The patentee has to use contract obligations, and of course those are harder to enforce because contract has a privity requirement that the patent law doesn't have. The Federal Circuit, however, had two longstanding doctrines that really limited the scope of patent exhaustion in important ways. One, in a case called Mallinckrodt, said that if the patentee conditions the sale, imposes post-sale restrictions on use or resale, those restrictions are enforceable under the patent law. Obviously, that conferred tremendous power on patentees in terms of their ability to preempt or limit secondary markets for repair, for resale, and to control those markets for themselves. The Supreme Court unanimously said, no, you can't do that. Only contract remedies are available to the patentee once there is a transfer of title. And the consequence of that, obviously, as the court said, is to promote competition in these secondary markets, which is what the patent law provides for. The court said patent law gives an important right and incentive to the patentee, but we're not going to expand the monopoly in this dramatic way. The second issue was, okay, that's the rule for sales in the U.S. What if the U.S. patent owner authorizes a sale outside the U.S.? Does that exhaust the U.S. patent rights? Something that's very important in our world of global supply chains. You know, the computer that you all are probably looking at, or maybe the iPhone that you're looking at, has thousands of components that embody tens of thousands of patents, and those components are produced in different places in the world, shipped to assembly points, and so the place of sale may have nothing to do with where the finished product is being used. And for companies in that business, knowing that that all of the patent rights are exhausted when there's a sale is very important in preventing patent claimants from appearing on the scene once the finished product arrives in the United States and saying, oh, there wasn't a sale within the United States of the component that embodies my patent, so I get to prevent sale unless you pay me a significant settlement. Supreme Court said we're not going to allow that. We're going to apply the patent exhaustion doctrine to sales outside the U.S., a very significant change in patent law that overturns another Federal Circuit case called Jazz Photo, and that really opens the door to global supply chains and eliminates uncertainty and the risk of patent troll lawsuits. Go to the next slide. I want to mention quickly two other cases that the court decided, both of which ruled against the patent owner. Samsung v. Apple, a very important case about infringement remedies for design patents. The court basically said, if you allege an infringement of design patents, you don't automatically get all of the profits on the finished good. There has to be some assessment of what the value of the design patent is. And in Life Technologies, another question about broad remedies for inducement of infringement, and the court, as it has in recent years, rejected a broad inducement remedy for fear of the consequences on technology industries. In both of those cases, especially because there were 8-member courts, the court ruled narrowly and left a bunch of questions open. We have a blockbuster case for next term in the patent area. Congress in 2011 created or souped up, I would say, a process to enable the PTO to administratively invalidate patents called inter partes review. It's been a very important remedy for financial services companies with respect to business method patents, for technology companies with respect to business method patents. Oil States Energy is a challenge to the constitutionality of that system, whether the PTO can exercise this authority or whether only an Article III tribunal can invalidate patents, and whether parties have a Seventh Amendment right to have contested facts in those proceedings determined by a jury. Obviously, if either one of those claims wins, the inter partes review process is going to have to undergo significant changes to remain in operation. The SAS Institute case, another question about inter partes review, whether the PTO can narrow the scope of challenges or it has to decide everything that a party brings to it. So next term promises to be another interesting one in the IP area. If we can go to the next slide, although we didn't have a lot of interesting cases in administrative law this term, there certainly are two cases coming down the pike. that are going to be headed to the Supreme Court dealing with administrative agency constitutionality. One has to do with the Consumer Financial Protection Bureau, which has a single director who is removable by the President only for cause. Question whether that limitation on the President's authority violates separation of power principles. For-cause limits have been upheld in the context of multi-member commissions, but never in the context of a single agency. And as those of you who are listening who are in the financial services industry know, this is a single agency that has an enormous amount of authority, not just over the financial sector, but over large parts of the economy. So definitely a decision to watch. The Lucia case, the constitutionality of how SEC ALJs are appointed, whether they have to be appointed by the SEC because they qualify under the Constitution as inferior officers, or whether they are mere employees who can be appointed by anyone. If they are inferior officers, there will be a serious question about whether they therefore have to be dischargeable at will. At the end of last week, the D.C. Circuit issued an order saying it was split 4-4 on this question, the en banc court. So I think we can safely say that that's an issue that almost certainly is going to go to the Supreme Court because the 10th Circuit has already held that the SEC appointment process is unconstitutional. Can go to the next slide. This remains the most First Amendment friendly court in recent history, and it ruled in favor of 2 First Amendment issues this term. Mattel v. Tam is a case involving the constitutionality of the provision of the trademark law that bars registration of trademarks that are disparaging. And the question is, was that unconstitutional viewpoint discrimination? The government made the trademark protection available generally, but not to things that the government determined were disparaging. And the Supreme Court, not surprisingly, said this is unconstitutional viewpoint discrimination. We don't even have to address whether this question should be evaluated under the general stringent free speech protection or under the lesser standard for commercial speech, because it was invalid even under that less stringent test. Some people thought this was going to be the case in which the court expanded First Amendment protections for commercial speech, but that didn't happen because of this alternative ruling. The Packingham case, not a case involving companies, a case involving sex offenders, but interesting because it gives us an insight into the court's view of technology. This is a statute that prohibited someone who was a registered sex offender from accessing a commercial social networking website with the knowledge that minor children can frequent the site. And the court held the law unconstitutional on the theory that it was not narrowly tailored to serve a significant government interest, really based on the fact that the breadth of that restriction would have meant that these individuals could not access eBay, the Washington Post website, WebMD, let alone Facebook, and other networking sites. This was an opinion written by Justice Kennedy, who was a booster of the First Amendment, and it includes some very broad language that led some of the justices actually to write separately, including the quote on the screen about the need to exercise extreme caution before suggesting that the First Amendment doesn't protect access to these new media. So certainly a continuing interest in the court on how new media interact with the protections of the Constitution.
So turning to the court's bankruptcy cases from this term, which I will go through fairly quickly, both because we're running out of time and because they're somewhat intricate. The Jevick Holding case is pretty interesting. It's about the way in which a court can structure a Chapter 11 dismissal. Chapter 11 cases typically end in one of three ways, either with a negotiated plan or with a transition to Chapter 7, or sometimes with a structured dismissal. And a structured dismissal, or with a regular dismissal. A structured dismissal is one that puts people back not exactly in the status quo before the petition was filed, but puts them back in a different position. And in this case, a group of workers with a priority wage claim challenged the district court structured dismissal because it favored lower priority unsecured creditors. And the lower court said that this was okay, that even though it put the workers out of the place in line where they otherwise would have been, it was permissible because they weren't going to get any money in any event absent a deal. So at least this way they had a chance of getting some money. And the Supreme Court said, no, bankruptcy courts don't have the authority to approve a structured dismissal that changes the ordinary rules of priority without the consent of all of the affected creditors. So that was the holding in Jevick. Henson is interesting in part because it is the first opinion drafted by Justice Gorsuch. And as is typical for a justice's first opinion, this was a case where the court was unanimous. And the opinion is interesting. It's beautifully written. It's a great read on an otherwise somewhat dry topic, at least for people who are not bankruptcy lawyers. And as Andy pointed out, it is characteristically textualist in nature. The FDCPA applies to people who collect debts that are owed or due another. Here, the defendant had purchased debts and collected them for its own account, and the court held that, in fact, that's not a debt collector because it was collecting the debts on its own account and not debts that were owed to another party. And finally, in the Midland Funding versus Johnson case, the question was whether it violates the FDCPA for a creditor in a Chapter 13 proceeding to file a proof of claim that is time-barred. The statute precludes representations that are false, deceptive, or misleading. And the court held that even though a proof of claim that's time-barred may be unenforceable, that doesn't render it misleading. So we can go on to the next slide, please.
Arbitration and protecting the enforceability of arbitration agreements is an important area for a lot of companies, increasingly important as the court has expanded the ways in which the FAA protects those agreements and prevents state law from intruding on their enforceability. This was another term in which the court has continued to be willing to intervene to correct lower courts who fail to follow the FAA and are all too willing to adopt rules that discriminate against arbitration with the goal of thwarting arbitration agreements. Kindred, a case that we handled in which the Kentucky Supreme Court had held that although powers of attorney that authorize entering into contracts generally can authorize are effective to authorize the attorney to enter into all kinds of contracts, in order to be able to enter into an arbitration contract, the Kentucky court said there must be express authorization in the power of attorney. And the justification that the court gave was that arbitration agreements are special because they waive what the court termed the sacred right to trial by jury. A pretty clear decision that focused on precisely the kind of hostility to arbitration that the Federal Arbitration Act was designed to prevent. The Supreme Court granted review and reversed and held that this Kentucky rule discriminated against arbitration agreements in violation of the FAA. So another useful opinion, not just in this area, but to show state courts that the Supreme Court is ready, willing, and able to intervene if they stray from the path that the Supreme Court has charted in terms of not singling out arbitration agreements for discriminatory treatment. Next term, on the next slide, the court has up a very important set of cases in the arbitration arena. In the wake of the Supreme Court's decision in Concepcion, holding that class waivers in arbitration agreements are enforceable and are protected against state law that would render them unenforceable, the NLRB decided that the National Labor Relations Act contains a protection for concerted litigation action by employees, and that NLRA protection, the NLRB held, renders invalid any class waiver in an employment arbitration agreement. So basically, the NLRB held that because of the National Labor Relations Act, the Concepcion decision doesn't apply to employment arbitration agreements. So a ruling with huge ramifications for millions of employment agreements. There are many, many cases, administrative cases, in which the NLRB has found the inclusion of these class waivers to be unfair labor practices. There are many cases in which employees have relied on the NLRB's ruling to prevent the enforcement of arbitration agreements in court. And the Supreme Court granted review in 3 of these cases to decide whether the National Labor Relations Act does displace the FAA. Before the change in administration, the Justice Department had supported the NLRB's position in this. After the change of administration, just last week, the United States filed an amicus brief opposing the NLRB's position and saying that, in fact, the NLRA does not displace the Federal Arbitration Act, and the Federal Arbitration Act requires the enforcement of these class waivers. The NLRB is adhering to its position for now. The President has not appointed new members to the NLRB. So for now, we'll have the interesting situation where, in addition to the private parties, employers who are challenging the NLRB's position, we have the United States opposing the NLRB, and that obviously will be an extremely important decision in the arbitration area for next term. On the next slide, we talk about a couple of other statutory decisions that are worth attention. The Bank of America against City of Miami case. It's an interesting case that I think, again, gives defendants a new area to think about in terms of defending against broad attempts to impose monetary liability based on federal law. The City of Miami sued a number of banks under the Fair Housing Act, not because the banks were discriminating against Miami, but based on a much more lengthy chain of causation. Miami's theory was the banks had engaged in predatory lending practices that targeted minority borrowers. Those borrowers defaulted on their loans. Those defaults led to foreclosures. Foreclosures led to blight in many areas of the city, and the blight produced not only the loss of tax revenues, but the need for the city to spend extra money on police protection and other matters. And so the city was suing to recover those alleged losses. The question in the lower court was, does Miami have standing to do this? Is this lengthy chain of causation something, an injury that was within the statutory standing provision of the Fair Housing Act? The court said yes, there is standing, but to recover damages, the city is going to have to demonstrate proximate causation. The court said all of these monetary remedies are enacted against a common law backdrop where proximate causation is a requirement. Therefore, the city is going to have to not just meet a standing requirement, but also show that the bank's alleged misconduct is a proximate cause of the city's injury. And what the court said is that requires some direct relation between the injury and the injurious conduct, and we'll see how the lower courts assess this quite lengthy chain that the city is relying on. Next term, a very interesting statutory interpretation case about the Alien Tort Statute that's been a subject of litigation before. The Second Circuit has consistently held that the ATS does not impose liability on corporations. That ruling was once extremely important in preventing corporate liability. Some rulings in the interim about extraterritoriality in the Kiobel case by the Supreme Court and limits on the scope of aiding and abetting liability have given corporations additional arguments against liability. So the question of corporate liability has become somewhat less important, but obviously would be a very important protection to have, and we'll see what the Supreme Court does in the Arab Bank case next term. We can go to the next slide.
So just just a couple of procedural cases that the court decided this term. One is Goodyear Tire and Rubber versus Hager. This relates to a district court's inherent power to order sanctions. In this case, the district court found that Goodyear had engaged in pretty serious discovery misconduct, and it awarded the plaintiffs a sanction in the amount of all of their legal fees since the abusive discovery conduct began. And Goodyear challenged that because the district court's power to order that kind of sanction is limited if the sanction is inherently punitive. If the sanction is punitive and not compensatory, then the defendant is entitled, or the opposing party is entitled to criminal due process protection. And the court held that, indeed, an award of attorney's fees that is greater than the opposing party spent in order to deal with the discovery misconduct is a punitive sanction and does need to be accompanied by those protections. McLean just addressed the standard of review for an EEOC subpoena enforcement decision by a district court. The Supreme Court held, unsurprisingly, that the standard of review should be abuse of discretion because the district court is in a better position than the Court of Appeals to determine whether the subpoena is reasonable. The Watersplash case determines that the Hague Convention permits service by mail, and next term the court will hear an interesting case, a challenge to an EPA regulation that defines waters of the United States and where that challenge may be filed, whether it can be filed in the district court or whether the Court of Appeals has exclusive jurisdiction over that case. That's a Mayor Brown case for next term. And we will wrap it up with the last. And
our last slide deals with a couple of criminal law issues. One case the court decided this term, sort of an interesting one, the federal bank fraud statute. A clever defendant said, well, I didn't intend to defraud the bank. All I wanted to do was steal money from a depositor. And the court said, no, that's defrauding the bank. Don't worry, you're still liable. Interestingly, next term, the court will have another in the series of cases that it's had about the application of the Fourth Amendment to technology. We talked a little bit about the First Amendment. 3 years ago, the court decided in the Riley case that the search incident or to arrest exception to the warrant requirement couldn't be used to get access to the entire memory of a cell phone because of the huge amount of information stored there. In Carpenter against the United States, the question is also relating to cell phones, but this time to the geolocation information, the cell tower information that cell phone companies record as you move around the city or move around the country. In this case, the government wanted the records for this individual for 127 days. Obviously, those records will show a lot about someone's life and allow a lot of information to be figured out about doctor's appointments, religious beliefs, all kinds of things. And so it will be very interesting to see whether the court applies the Riley approach in this new technology context. With that, that's the end of our presentation. Thanks very much for joining us. Again, if you have any questions, feel free to send either of us an email, and we'll be happy to answer them. And we look forward to doing this again next year. Thanks again, and have a good day.